Well, our featured topic tonight, as you know, is Gordon Park. As you also know, the Park District did decline our invitation, but I do have a statement that Mary Ellen Penicook dropped off tonight and would like me to read. Her statement is, Dear Katie, we support the Citizens Council's objectives to highlight potential voter issues. Unfortunately, engaging in a debate with opposing counsel on the eve of a trial is an inordinately lengthy and costly legal proceeding and not the best interest of local residents, taxpayers, or the Park District. We would be happy to address the issues after the resolution of the ongoing legal proceedings involving Gordon Park. Sincerely, Mary Ellen Penicook. We have Tom Beyer, who is a representative of Friends of the Park. He is also, he's technically an attorney, a part of the legal team. So, welcome, Tom. Thank you for coming. And I'll hand the podium over to you.
Thank you so much.
Katie, thank you. And I thank the Citizens Council for inviting me. I want to make it clear that I don't see this as a debate. I thought that my purpose here is to give some information, and I intend to keep it as fairly factual as possible. Is there anybody here from the Park? I want to make it also clear that anything I say here today is not intended as a communication to the Park District in any way, shape, or form. I do know that there's a gentleman here from Mansell Lake. Who are you, sir?
My name is Jason Wilson. I'm a paralegal there, but I'm not technically from the Park District. That's why I didn't raise my hand.
Okay. And you are recording. I'm one of 3 attorneys that represent the Grange Friends of the Parks and Mr. Coriel. The other 2 are Art Wilbur and Joan Johnson. Yeah. But what I do is step back from a moment and give you some background as to how we get where we are, and I think that'll fill in a lot of the question of how the objectors have gotten to their position. When I say step back, I mean way back into the 1800s. If you go back in the 1800s, during around 1850, you wouldn't find any parks in most cities. They just didn't exist. What did exist, however, was a fledgling idea of the garden cemetery. And so what happened in a number of cities is these cemeteries were built that, of course, sort of preserve area with gardens and paths, and people who lived in cities where there wasn't much open space started using these cemeteries for weekend picnics. They would actually go and picnic in the cemeteries along the graves. Why? Because it was the only space available. So out of that was born the American park movement. Somewhere around, after the Civil War. During the Civil War, obviously, everybody was involved in other things. So after the Civil War, in around 1880, state legislative bodies in Illinois, the General Assembly, started on a case-by-case basis chartering parks. And the idea was that these parks would acquire property, that property would be available to all the public, and they would preserve it. That this property would be available at least into any known future. And it would be preserved not only for them, but for their descendants, and for all people. So a park generally is available to anyone who wants to use it, any citizen. And I don't mean the citizens of LaGrange. A citizen from Alabama can come in and use our parks. And it holds the other way. There have been cases, particularly in the eastern seaboard, where park districts try to limit the use of their parks to only their residents, and the courts have, I think unanimously, I'm not sure of that because I haven't looked to make sure there's no case opposite, but pretty much unanimously decided that they simply can't do that. And they can't sort of do it either. So they can't charge their residents $5 and everybody else $50. They parks have to be open, and they're open to the public. So around 1887, however, it was recognized that there might be a time when a park district needs to sell a little piece of property. So the Illinois General Assembly enacted a statute that would allow them to sell less than 1 acre, provided they got permission from a circuit court judge. That has not been a controversial statute throughout its history. There is one case that does cite it, but it cites it for reasons that aren't interpreting that statute. Otherwise, it has never even been discussed by the appellate court. The reason we think the General Assembly decided to do this is it ran into some practical parts. Maybe you had this little sliver of land that really needed to be sold to somebody else so they'd have access to their property, put it in a driveway. Maybe you had an embarrassment of riches. And some of the outlying towns were able to acquire huge parcels of land, and they really didn't need all those parks. And so it made sense that they should be able to sell part of that. And you can envision other possibilities. For example, the character of the area changes completely. It becomes entirely industrial, and there's nobody to use that park. Or somehow it gets polluted to the point where it'd be dangerous to use it. And you can see why you would want to be able to sell that. Now, this statute goes forward until 1985 without any change. In 1985, the General Assembly changes it to make it 3 acres instead of only 2, or 1. The reasons for that seem to have been personal to a particular legislator who, in his district, there was a golf course, and they wanted to sell off 3 acres of it, and they needed a change in the statute to be able to do it. There is another statute, and that statute would allow the sale of property, again, only if you got permission. And how do you get permission under that statute? You do a referendum. And then you have to have a public sale, and there's some other technicalities that you have to meet. Now, turning to the sale of Gordon Park, to give an idea of what we're talking about. This diagram shows that the yellow is the YMCA property. In the red and pink is parkland. If the sale were to go through as proposed, all of the red and the pink would be sold. To give you an idea how much property that is, it's about 3.5 acres, which is equivalent to selling Whitehall Park, the entire Whitehall Park area. It's not a small parcel. I'll just set this up here. I don't know how visible it is. So the Park District decided that it wanted to sell that property. And in September 2007, they filed an action to ask the court for permission to sell it. And they argued that that property is less than 3 acres. Quite a bit of argument went on. There was a motion for summary judgment. I wasn't involved in that case, so I don't know all the details. But in on June 27, 2008, that case was dismissed because the circuit court determined that it was actually 3.5 acres that was being sold, and so it didn't have jurisdiction under the statute. The Park District did not appeal that case. Instead, they attempted to go under the other statute, which is the one that requires a referendum. I think we're all aware of the referendum and what happened there. The ultimate vote was about 45% against and 55% in favor. Putting that a little bit of perspective, that means that approximately 370 people had changed their minds. It would have gone the other way. But the referendum did pass. The problem was that the Park District then went on to hold its sale. It had to be a public sale. And it wasn't on our position, wasn't public. And the judge agreed. It wasn't public because the only entity that really could have bid at that sale was Atlantic Realty Partners. Why is that? Well, Atlantic Realty Partners had zoning already in place for itself. It also had the street already in place for itself, and was the only entity that was given any information about EPA issues, whether or not there was toxic waste or any other problems on the property. So the court enjoined that sale. The Park District then decided that it would take another tack. It took this portion in red and swapped that with the Park District, with the Village of LaGrange. So the Village of LaGrange would now own this property, and so they could then go under the statute because this property and this property together is only 2.2 acres. Now, whether or not you agree with that as sort of a tactic is a different issue, and as, again, I'm not going to get into any argument here as far as our position on that. But they did that. The court has held that it does have jurisdiction, and at this point the court is aiming towards a trial. That'll happen in October. So the question, I think, has been, why did the Grange Friends of the Parks object to the sale? It's really a difference, I think, in philosophy. They look at this and they say that this is a park district that has half the land, or less than half the land, that it should have for its population. And that fact is in their own open space plan. If you read page 32, I believe, of the plan, they point out themselves that they have about 40% of what they should have. But more importantly, on top of that, we live in an area where there is no available open space. I've made this kind of a joke before, but I think it's sort of apropos. Short of a 747 making an unscheduled landing in LaGrange, there is never going to be large tracts of open space. So if the Park District sells this land, it can't get it back. There's no place to find it. It just doesn't exist. So from their point of view, what they're saying is park districts were created to preserve land for the public. Park districts weren't to sell that land, but under certain circumstances, the General Assembly said they could. And their position is they haven't met those circumstances. And that's really it in a nutshell. On the other side, we have the Park District who wants to sell the property because they believe, at least their public position is, that they can use that money to then revitalize Gordon Park. Again, we have issues over that, and if you want to ask questions about that, I'd be glad to answer them. I'm slow to get into an argument about those issues. I guess except maybe to make this observation. I've lived here since I was 4 years old. I played in Gordon Park. I played Little League there. I never had trouble using those fields because they were flooded. And I guess I'll leave it to anybody else to draw a conclusion from that statement. That simply is true. So, questions?